All rise. Before the beginning of session, President J. Mayor presiding.
All right. Good afternoon, everyone. Please be seated. We have a little bit of an issue that arose during the lunch hour. Juror number 76 was eating lunch and was wearing his badge. And there was somebody apparently from the media who approached him and asked him how far along they were. And then proceeded to say, "I know I'm not supposed to talk with you." And this person has been described as somebody who has been in the courtroom on a couple of occasions and who has been wearing a diabetes patch. Obviously, this is not something that we can accept. The juror's response was, "I'm not allowed to talk to you." And so that's where things are. I wanted to share it with you because it appears that the juror handled it 100% appropriately, and then also reported it to the sheriff's deputy, who then reported it to me, and I'm reporting it to you. Okay?
Thank you, Judge.
And if we see somebody who fits that description, who shows up in this courtroom, whether they be a part of the media or not, please let me know immediately so that we can consider what needs to happen next. Any questions? Yes. I've just had a note given to me by the sheriff's deputy who indicated that I believe she's in the back, currently light blue dress. Ma'am, is that you?
Yes.
Okay. Did you have any contact with the juror at lunch today?
I asked him how it was going, and his response to me was not that he couldn't talk. He did start talking, and I walked away.
Not knowing who's telling the truth at this point, you need for me start.
Ma'am, please state your name.
Alexis Stevens?
Can you spell that for us, please?
Alexis. Last name is Stevens, Stevens.
And are you with the news agency?
Yes, sir.
Which one?
The Atlanta Journal-Constitution.
I'm going to start by saying that you are not to have any contact with members of the jury. Not friendly regardless, not how's it going. Nothing that would elicit any sort of feedback from them to you about the nature of this case or anything. Do you understand that?
Yes, sir.
We've been trying this case, we're in our 4th week. And what we don't need is members of the press putting themselves in a position where they're causing us trouble. I am mistrial has been made by the defense. What says the state?
If we need to get more information, I think that would be appropriate. But at this point, there is no sufficient basis to grant this trial.
This reporter stated that the jurors did respond to her, and I think we ought to at the very least inquire into that, because if the juror is responding to her substantively and not just, I can't talk to you, then there is grounds for mistrial.
All right. I suppose that there is a need to follow up this. Ms. Stevens, was anything of any substance about the nature of this case said to you?
No, sir.
Anything else? Motion for mistrial is denied. Word recess. Did you discuss this case?
Correct. And I think also whether or not it would affect the juror's ability to decide the case fairly and impartially.
Would this incident, would this contact affect your ability to fairly decide this case? Okay.
I think, given what the agency reporter said, that perhaps a question, did you respond in any way to the spectator or the member of the press?
Well, that's, did you discuss this case? Discuss this case. I'm comfortable with the questions I've asked. I think that they get to the heart of what's the key concern. And any other comments?
No, I think maybe just to also get on the safe side, whether or not he discussed anything about that with the other jurors.
All right. We also have a note from the jury, and it's J5. And it says, parties to crime, 30 July 2019. To be guilty as party to a crime, must the defendant be present at the time of the crime? Thank you for considering this question, and it's signed by the voters. I marked it. It's being made part of the record. Ms. Mull, would you like to look at the note? What I'll do is I'm going to wait to respond to this note until after we've dealt with the other issue. I think that given the way that these questions are formulated, there might be a need for me to have a contact with the entire jury especially if the answer to question number 4 is yes. And if the answer to question number 4 is yes, have we got through what will likely to occur at that point? I guess it really depends upon the nature of that conversation with the other jurors. I'm going to have to inquire, aren't I? Let's have juror number 70. I'm sorry. Juror number 76. Step up, please.
Yes.
Do you have the jurors named and on your sheet? Okay. Juror number 76, is that correct? All right. Apparently, during the lunch break, you were contacted by someone, according to the sheriff's deputy. Is that correct?
Yes, sir, I was approached at lunch.
By one person or more than one person?
Just one person.
Did you discuss this case with that person?
No.
Would this contact affect your ability to fare in deciding this case?
No, sir.
Did you discuss this contact with the other jurors?
I told them that it happened, yes, sir.
And what did you tell them?
I told them I was approached, so I was told to tell the bailiff. That's all I told them.
All right. Okay. Did you say anything at all to this person?
I was asked if we were close to finishing, and I said I don't know because I hadn't been approached. That's all I said. I don't know.
Okay. All right. This is what I'm going to do. I'm going to give the jury a 15-minute break. Okay? And then we're going to come back.
Yes.
Thank you. Okay. No, you tell them that they're taking a 15-minute break.
I did,
All right?
and they all said they'd stay in the room.
But I don't want there to be any deliberation for 15 minutes.
Yes.
I want them out of the jury room into the hall.
Just don't y'all out on deliberation.
Okay, is that everybody?
Yes, sir.
Thank you. All right. So I believe that what I heard is that the juror indicated that he mentioned to the rest of the group that he had been contacted, just to let them know that that had occurred. Is that what the two of you have heard?
Yes, sir.
All right. I don't see, under these circumstances, the need to do anything else, except perhaps to bring them out as a group and to let them know that they are to do exactly what we have seen occur in this case, which is to report back to us if, in fact, somebody who is a spectator approaches them and get a description of that person and provide it to the bailiff so that I can share it with you. And again, remind everybody not to discuss this case, not to engage in any social media, to avert, not to do any investigation in the aspect of this case. Is that acceptable to you guys?
Yes, Judge.
All right, let's have the jury come into the jury box, please.
I think they went that way.
Well, you can get them all in here, that'd be great. Yes.
If I may, reassert our motion for this contact.
All right, under the circumstances as they present, the motion is denied. Perhaps while we're waiting, we can address the note. Sure. Can I give one to you?
You were reading from it.
Okay. Was it returned to me?
I've got them all, Your Honor.
Just 1 second, please. Just keep right there in the hall for 1 second.
Yes, I'll stay with them.
Just stay with me for 1 second.
Yes, sir.
Okay, I think the short answer to this question is no.
I think the answer is in the instruction. I don't know that we need to give them additional. The answer is in the instruction.
And Judge, I think they had the instruction, the one, to the standard instruction they received, 14110, parties to a crime. I agree with the court, I think it's a very short response, no.
If you say no, flies in the face of your other instruction about mere presence, so it's going to conflict them. I think that it's better to just leave it the way it is and let them decide based upon the instruction. Just like we haven't given them any instruction on parties to a crime yet. We've said rely on the instruction. I think this is the same sort of
I
situation.
think that's good feedback. The charge has mere presence, mere association, and it also has party to a crime. And so if I'm answering this question, then I'm sort of entering into the thicket of all of that analysis, even though I don't believe it would be incorrect just to simply give that one-word response. But Ms. Mull raises a concern. Considering it further, there may be some merit to it. What do you think over on this side?
Judge, I don't think it would be improper to simply answer their question clearly. This is something that as far as party to the crime, leads into the second question that we've gotten specifically on this particular issue. It is not an incorrect statement of the law to say that it's no. As far as mere presence is concerned, I think that's, that their question is whether or not the defendant has to be present.
What if I were to give mere presence, mere association, and parties to a crime?
Recharge all of them together.
Recharge all of them together.
I think that would be appropriate. And perhaps knowledge too.
And knowledge.
I'd like that better than no.
Okay.
Yeah, so I think parties to a crime, knowledge, mere presence, and mere association. adding in the portion that we had discussed into the parties to the crime section.
So I have 4 written down. Parties to a crime, mere association, mere presence and knowledge. Let me just take that. My charge is in the room with them. So if I could just have one of yours, please. So that would be 27, 28, 29, and 30.
Correct.
Ms. Mull? Okay. So the first thing that we'll do is address this contact issue. The next thing we'll do is read these 4 charges, and then I'll excuse them.
Does the court have the language, the proposed language as far as no?
Pardon?
As far as the answering the question about no and now in response?
Well, I think that this is sort of a substitute for the no.
Okay.
These are 4 charges that need to be considered together in and around this issue. Agreed? Okay. All right, let's do that then. And why don't you remind me, again, Mr. Chase, I have the follow-up question is does anyone think that they can't be fair and impartial, or put it in a different way? Is there anybody who?
Yeah, the question that was asked by the trial court in the Causey case was based upon whatever was said in the jury room this morning and whatever happened last night regarding the incidental contact. Is there any one of you that cannot be fair and impartial? It cannot be a fair and impartial juror as a result of that contact. If you cannot, please raise your hand.
Let's bring in the jury. Okay, ladies and gentlemen, it's been reported to me that there has been some incidental contact with one of your number, and that was reported by the juror to the bailiff, as I had previously indicated, should be done. And it's further my understanding that the juror shared with the group the fact that this incidental contact occurred, and that in fact this juror had reported it to the sheriff's deputy, who then reported it to me. First of all, let me ask everyone in the group just a couple of quick questions. The first is, based upon what that juror reported in the jury room to the rest of the jury, is there anyone who is on the jury who cannot be fair and impartial? If you cannot be fair and impartial based upon the information provided by that juror about his incidental contact, please raise your hand. Is the state and the defense satisfied with that inquiry?
Yes, Judge. For the record, there were no hands.
All right. So that's the first thing. The next thing that I'd like to say is, if you should be contacted by someone, what you are to do is to do exactly what has occurred, which is to reach out to the sheriff's deputy and share that information with us, and we'll take it from there. The next thing that I'll say is that you can see how important the instructions that I've given you at the beginning of the trial become. It's very important to the integrity of this proceeding that you not have contact with anyone about any matter associated with this case. And you are not to engage in any posts on social media. You are not to do any investigation in connection with this case. You should stay away from social media in all of its forms until your service is concluded. Does everybody understand that? Does everybody understand why that's important? Okay. Does either the state or the defense have any issue or question regarding those comments that I've made?
No.
Let's shift over now to the question that you've asked us. Okay. The question you asked, and I'm just going to read it. It says, parties to crime, 30 July 19. That's the top. The substance of the question is, to be guilty as party to a crime, must the defendant be present at the time of the crime? Thank you for considering this question, and then it's signed by your foreperson. And after having discussed this question with the attorneys and considering possible responses, what we want to do is direct your attention back to the charge. And in particular, charges number 27, 28, 29, and 30. And I'm going to read them. Number 27 is every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Charge on page 28 is the charge of knowledge. Knowledge on the part of a defendant that a crime was being committed and that a defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that a defendant had no knowledge that a particular crime was being committed, or that a defendant did not knowingly and intentionally commit, participate, or help in the commission of any particular alleged offense, then it will be your duty to acquit that defendant as to any such offense. On the other hand, should you find beyond a reasonable doubt that a defendant had knowledge that a particular crime was being committed, and that a defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict that defendant. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consenting or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. So that is the set of instructions that relate to the issue that you have raised in your note. And at this time, I will excuse you to adjourn. Thank you. Does either party have any objection to this recharge? Definitely.
No objection to the charge, but we stand on our please.
All right, thank you. And I'll return this to the state. We're in recess.